If you are in the US and you do not have status, you do not have family that can file for you to get status, maybe you entered without inspection or you entered with a visa but you have overstayed that visa and you don't know what to do, and you have been a victim of a crime in the US, well, watch this video because the U visa may be an option for you, especially, like I said, if you have been a victim of a crime in the US. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The U visa was created in 2000 as part of the Victims of Trafficking and Violence Protection Act. The purpose of this was to help victims of crimes, witnesses to crimes, come forward and be able to help law enforcement prosecute these crimes. The U visa was specifically created to help law enforcement prosecute domestic violence crimes, sexual assaults, and other crimes while helping the victim or the witness gain status. The U visa is a law enforcement tool to help law enforcement be able to actually investigate and prosecute crimes, because this is what usually happens, right? There's a crime that's committed, and if the person that's the witness or the victim is not willing to come forward, sometimes those investigations go nowhere. And in the immigrant community, when someone does not have status and there's a crime committed against them, they are less likely to report those crimes. But with the U visa being available, law enforcement can use that as a tool to help the person that is scared to come forward because they're scared of being deported or being detained for their lack of status. So the person can go from being a victim of a crime to eventually getting their green card after their U visa is approved. The requirements for the U visa are as follows. First, you have to be a victim of a specified crime. The statute actually lists out what those crimes are, and we're going to talk about that. Secondly, you have to have suffered substantial physical or mental abuse as a result of that crime. Thirdly, you have to have some credible and reliable information that will help law enforcement. 4, you have to get a certification from the law enforcement agency saying that you have been helpful or that you are currently helping them investigate the crime or prosecute the crime. And finally, you have to be admissible to the U.S. or qualify for a waiver. Although the U visa is a helpful tool that law enforcement can use and victims of crimes can lean on in order to get status, it can take a very long time before you can actually receive that U visa. Congress only designated 10,000 U visas to be approved every single year. So there is a huge backlog because that is not a lot of cases that can be approved. USCIS is only allowed to approve 10,000 U visa cases every single year. This means that there's going to be a huge backlog. Right now it's about 15 years of waiting just for the U visa to be approved before you then talk about getting a green card. What USCIS does to help mitigate the waiting, right? You're going to wait that long because there's only 10,000. However, while you're waiting, USCIS can approve you for deferred action or parole so that you can legally be in the U.S. while your U visa is pending. As part of the deferred action, USCIS can also approve your work authorization, so you'll be able to work in the U.S. and live without the fear of deportation. So although it takes a long time to get the U visa, in the meantime, you can get some form of temporary status, work permit, and those are typically right now coming in about 2 to 3 years after filing. Before you can even look at U visa as an option, we have to first see if you are the victim of a qualifying crime before we get to whether you suffer substantial physical or mental abuse. We don't get to that until we find out if you are a victim of a qualifying crime. According to the regulations, these are the list of qualifying crimes: abduction, abusive sexual conduct, blackmail, domestic violence, extortion, false imprisonment, female genital mutilation, felonious assault, fraud in foreign labor contracting, hostage, incest, involuntary servitude, kidnapping, manslaughter, murder, obstruction of justice, peonage, rape, sexual assault, sexual exploitation, slave trade, stalking, torture, trafficking, witness tampering, and unlawful criminal restraint. And crimes like contempt, conspiracy, or solicitation to commit one of these crimes also count. And sometimes the crime that your state may have charged the person with does not fit into one of these specific languages. However, what we look at is the nature and the elements of the crime, right? Each state has their own statutes for what the crimes are. They have their own laws of these are the elements. These are the things that have to be met for this to be considered, a felonious assault. And each state is different, but as long as the elements, the nature, the requirements for that law matches what the federal definitions are, you can still use that, even though it's a different wording. That's what immigration lawyers are for, to help you do that. Now that we have determined that this is a qualifying crime, let's see if you are a qualifying victim. The first person that is a qualifying victim is the foreign national who has suffered the direct and proximate harm as a result of that crime. So if it's armed robbery, for example, you are the person that was robbed. That is the direct and proximate harm. If you are the victim's spouse, their child under 21, if the victim is under the age of 21, you are their parents or unmarried sibling under the age of 8. You can be a qualifying victim if the direct victim is deceased. If you're part of the crime, you do not get to then turn around and be a qualifying victim of the crime. Bystander that has suffered unusually direct injury as a result of a qualifying crime is also a qualifying victim. Here's an example of that. If you are the parent of a child and the child gets hit by a drunk driver and you witness that, you are a bystander. You were not in the crash, right? But you witnessed that and you have suffered unusually direct injury from seeing your child hit by a drunk driver. And then the drunk driver is charged with manslaughter. Well, guess what? You will still be considered a qualifying victim for U visa purposes. And by the way, if you are getting value out of this video, do not forget to hit that like button and share this video with anyone you think that will get value out of it. If we have determined that you are a qualifying victim, the next thing we want to know is, what is your particular criminal history? So you were not involved in this particular crime, but do you have criminal history that can then affect whether USCIS is going to approve your case? If the person has extensive criminal history or violent criminal history, that can affect USCIS's ability to actually approve the visa. If the person can show rehabilitation, USCIS can take that into consideration, but typically violent crimes lead to you not being able to get U visa. It is not enough that you are the victim of a qualifying crime. You have to also show that you have actual, reliable, and credible information, including facts about the actual crime. If you do not have any facts and you're not able to assist law enforcement, even though you have a qualifying crime and you are the victim of that crime, you would not be eligible for a U visa. As a U visa applicant, you also have to be helpful to law enforcement agency. So this can be the police, the prosecutors. It has to be an agency that investigates or prosecutes crimes. You will have to show that you have given ongoing assistance, or if the case is over, that you provided assistance to law enforcement. Again, this can be the police if they're the ones certifying, or the DA if they're the ones certifying. Ongoing assistance includes giving witness statements, testifying at a grand jury, doing lineups, testifying at a trial. Those are all part of you showing ongoing assistance. The agency has to fill out a certification, 18B. Is the form that the law enforcement agency has to fill out, certifying that you were helpful, certifying that you were helpful in listing out the crime that is the qualifying crime in that situation. The law enforcement agency can choose to not certify your case because maybe you did not assist them or they did not feel that you were helpful. In those situations, there's no appeal process to get them to change their mind. You can advocate, and what we do is advocate for a client and show law enforcement how you were helpful and hopefully change their mind in certifying your case. Next, you want to show that you have suffered substantial physical or mental abuse. Remember, the key word here is substantial. So what USCIS does here, they look at each case on a case-by-case basis. Here are 5 factors that USCIS looks at to determine if the physical or mental abuse was substantial. They look at the nature of the injury inflicted or suffered. They look at the severity of the perpetrator's actions. They look at the severity of the harm you suffered. They also look at the duration of the infliction of the harm and the extent. They also look at the extent to which there is permanent or serious harm to the appearance of the person, the health of the person, or the physical or mental soundness of the person. The more permanent or serious the harm to you is, the more likely USCIS is going to find that there was serious physical or mental abuse. None of these 5 things is a prerequisite to you being able to show substantial physical or mental abuse. But they do go together to, you can use a combination of these, or one of these can just be serious enough that it is enough for USCIS to find the substantial physical or mental abuse. So you don't always have to prove every single one of these. One of them can just be enough, depending on the seriousness of it, or a combination of them can be enough. You want to provide documentation for the physical or mental abuse that you suffered. This can be medical records, therapist notes, things of that nature, people that have seen the effects of that injury to you. Photographs of any visible injuries that you suffered can also be helpful here. Now that you know the requirements, let's talk about how you actually file a U visa. The U visa is filed on Form I-198. Remember, you need the Form I-918B from the law enforcement agency in order to start your U visa process. You yourself have to file the 918 while the law enforcement agency does the 918B. Most people that file for a U visa will need a waiver, either for overstaying a visa, entering without inspection, not having the proper documentation. For example, if they don't have their passport or things like that, you may need to go ahead and file this waiver. And that waiver is done on Form I-192. With this filing, you want to make sure that you have evidence of each of the things that I have talked about, right? Evidence of the crime being a qualifying crime, evidence of you being a qualifying victim, evidence of you helping law enforcement, right? Evidence of you having information that will be helpful to law enforcement. Again, the certification from the law enforcement agency kind of does those two things for you. Let's talk about my favorite part about the U visa, because this is something people don't even think about. You can include derivatives on your U visa. This means if you're married and your spouse does not have status, if you have children and they do not have status, they can be included. They will need to file the I-918 Supplement A. And let me tell you, your derivatives do not need to be physically present in the U.S. in order to be added to your U visa case. That's one of the key things that I genuinely appreciate about the U visa, is that not only do you get status at the end of that 15 years, your spouse, if they do not have status or if they are outside of the U.S., can also get status. Your children that are under 21 can also be added to your application as derivatives and be able to get status as well. And if they are in the U.S. without inspection or they need a waiver, right? If they need a waiver, you can also file that waiver application for them. Once your U visa is approved, it is good for 4 years. Okay, it is approved for a 4-year period. If you reach that, if you're almost at that 4 years, you can ask for an extension of your U visa status. However, what most people do is they apply for a green card, because you can apply for a green card 3 years after getting your U visa approved. And once you apply for your permanent residency and that is approved, you just have to wait another 5 years and you can apply for citizenship. So yes, it's a long-term plan, right? I typically suggest U visa to people that don't have any other option. They do not have family, they do not have children, they do not have any other way of getting status in the US, and this U visa is an option for them. I also suggest the U visa for someone that entered without inspection, so EWI, and their only relative in the US that can potentially file for them is their child. Because once you get that U visa status, you have an admission that you can use to then apply for adjustment of status in the US. So now you're no longer EWI, you now have a status and you can apply for adjustment of status through your child. Yes, it's a long-term plan, right? It's a very long-term plan. However, when that plan does work out, you can then get status through your child that's now 21. It is something that can be very useful in those situations. But if you have other options for getting status, I typically suggest exploring those options while also exploring the U visa, because the U visa is such a long-term plan that it can be a backup plan. This is not the first thing I discuss with people. We do explore it once I figure out there's no other options for them, or that there is an option, it's just not a viable option at the moment. If you are in a situation where you're trying to figure out what your immigration options are, and you're trying to figure out, is a U visa an option for you, or is there other things that would be better for you, well, go ahead and schedule a strategy session with me. This is a time for me to get to know you, get to know your situation, and think about things that can potentially lead to you being able to get status. You can do this by going to my website, lilylegal.com, and clicking on Contact Us, and you will be able to pick a date and time that works best for you for us to speak. You can also call my office at 508-443-1788 to schedule